Thank you, Mr. Speaker, for allowing me to make this statement. The AGC made a reference to the Court of Appeal on the City Harvest case, or City Harvest Church case. Two questions were asked on the 1st of February 2018, last week. The Court of Appeal released its decision on the reference. I want to set out the government's position now that the Court of Appeal has said what the law is. The key question related to the liability of company directors, governing board members, key officers of charities, officers of societies. When they commit criminal breach of trust or property which belongs to the organization, what happens? The Court of Appeal ruled that such officers are liable to be punished under Section 406 of the Penal Code. That provides for a maximum sentence of 7 years imprisonment or fine or both. The Court of Appeal also ruled that these officers do not come within the term or meaning of professional agent, and that therefore they were not liable for the more serious penalties under Section 409 of the Penal Code for CBT. Section 409 provides for a maximum of life imprisonment. The government's policy is clear. If you are a senior officer, director in the organization, you are in a position of greater trust. You have considerable authority to make decisions in relation to the organization's assets. If you abuse that trust, you should be more culpable, and you should be liable for more severe punishments compared with an ordinary employee. That's really common sense, and there can be no question about that. For the last 40 years, the law, as applied by the courts, reflected this principle. In 1976, the High Court ruled so in the case of Te Chua. It said that directors are liable for the aggravated offense provided under Section 409. After that decision, the position was clear, settled law. The law was applied in that way for over 40 years by courts in other cases. There are at least 16 decisions reported applying this principle, and there must be many other unreported decisions. In April last year, however, the position changed. The High Court ruled that directors cannot be liable under Section 409. That was contrary to the decision in 1976 and the way the courts have applied Section 409 over these 40 years. The government asked AGC what should be done, what further steps ought to be taken after the High Court's ruling. AGC advised that a clarification should be sought from the Court of Appeal by way of a reference. We now had two conflicting positions from the High Court. One, Te Chua in the line of cases that applied Te Chua, and second, the City Harvest Church case, where the court disagreed with Te Chua. The Court of Appeal gave its decision, as I said earlier, last Thursday, in response to the two questions of law submitted by the Attorney General's chambers. The Court of Appeal's decision means that there is now a lacuna in the law. As it stands today, ordinary employees can be charged under Section 408 of the Penal Code. That provides for more serious penalties for criminal breach of trust compared with Section 406. It is punishable, 408, it's punishable by mandatory imprisonment up to 15 years and an optional fine. Directors, however, can only be charged under Section 406, which provides for a lesser punishment up to 7 years jail or fine or both. The Court of Appeal itself acknowledged this gap in the law, and it said there was no good policy reason to ignore the heightened culpability. I quote, no good policy reason to ignore the heightened culpability of directors and key officers of charities, societies, companies who commit criminal breach of trust. The Court of Appeal also pointed out that the obligation of the court is to set out the legal position correctly, what the law says, and leave it to Parliament to amend the law as it deems fit. It is now up to Parliament to amend the law, and that we should do soon. We will ensure that legislation provides for higher penalties for directors and other senior officers who commit criminal breaches of trust. We hope to make the amendment together with the other wide-ranging amendments to the Penal Code, which I've spoken about them. To the House, let me make one final comment. We are aware that many have expressed their dissatisfaction with the outcome. Expressing one's unhappiness with court decisions is fine, but it should not sink to the level of abuse, insult, and contempt. We have seen comments online that the judges let off those who are rich, that some judges were lenient because they were Christians, and so on. That is not right. Judges should not be personally attacked, their integrity impugned, just because people do not agree with their decision. There may be unhappiness. People are entitled to disagree with the decision, but let's not attack the judges. The government believes that the sentences are too low, but the sentences reflect the law as it stands after the High Court's decision last year, confirmed by the Court of Appeal. The courts decide these matters. All of us have to respect the decision, regardless of whether we agree or disagree with it. Thank you, Mr. Speaker.